I'm going to start by saying this. So pre-suit, which is not what we're talking about today, but pre-suit is very different from litigation. The documents that we want are not the same. Sending records to an adjuster is a very different thing than producing records during litigation, during discovery. Personally, in our practice, right before we file our lawsuit, I am going to, me or one of my paralegals is going to ask you for records if you're a medical provider. And that is because we are going into litigation, and the types of records we need, or the volume of records we need, is anything that you would produce if you received a subpoena. So normally medical providers give us fairly limited documentation because we don't need all of that stuff when we are just in pre-suit. But now we're going to have to ask for everything, and I mean everything, and we'll talk about what we need and why. Okay, so let's talk about the good old days before this statute was enacted. We used to allow patients to treat for as long as they needed to, up to 4 years, because the statute of limitations was 4 years. We would then, if we were not able to settle pre-suit, we would file a lawsuit. We would litigate for as long as we needed to. And then we would tell the court we were ready for trial. So we would be able to get everything in place and then say we're ready for trial and then go to trial. When we asked for the court to impose deadlines, that's when they would impose deadlines for the most part. Now we're in the personal injury Wild West with this new statute. And when we have to file suit, which by the way, we have to do within 2 years now because the statute of limitations is just 2 years on negligence cases, we are automatically given a trial date. We are automatically given deadlines based on the trial date. There are absolutely zero continuances now, and discovery closes when it closes. So in other words, if you give us something late, it's not coming into evidence. And the significance of that is that, unfortunately, if we didn't have the document and we weren't able to get it into evidence, your bill's not getting paid. So the impact of the new statute is that cases are moving a whole lot faster. The information we need faster. The documents we need faster. And we are going to need a lot more provider and support staff at provider offices depositions and just information in general. So now in this new time, we have to know from the very beginning how we're going to litigate a case. We have to know what witnesses we're going to call. We have to know what depositions we're going to need to take. And we will have to know what evidence we're going to present, because we have to file something at the very beginning of a case called a disclosure that tells the other side all of those things. I think when it comes to medical records, there are kind of two schools of thought. The first school is, don't give me documents that may be harmful to my case. Don't give me letters of protection, because I can only produce what I receive from the provider. So it's sort of like plausible deniability. The other school of thought is, give me everything, give me all the documents you have, and I'll produce all of it, whether it hurts me or not, and I'll deal with the consequences later. I don't know which of those is correct, and I think the way we all handle it is sort of based on what the medical provider does. But what I can say is that when we're asking for documents now, when we're in litigation, we need them quickly, and we need all of them. Defense attorneys are waiting until the very last minute to file motions, and what they're doing is they're filing these motions to limit the evidence we present based on this new statute. So until these motions are filed, we don't know if there's going to be an argument or even what the position the defense attorney is going to take until these motions are filed. And because they're waiting until the last minute, we don't have time in a lot of instances to get new experts or get additional information, or even sometimes it's a very tight timeline to respond to these motions. Some of the arguments that defense attorneys are making, or an argument that some defense attorneys are making, is that the new statute shows only what we are allowed to present to the jury. And some defense attorneys are arguing that in addition to the evidence we're allowed to present, they can present certain evidence that we'll talk about. Obviously, if they don't file a motion, we are not going to produce documents that limit medical expenses. That's stupid. We would never do that. That hurts our case. But if they do file a motion, or if we know this particular defense attorney, and I know that they're going to file this particular motion and challenge our records, I'm going to have to know that there's an LOP. If there's an LOP, I'm going to have to know if you sold the bill, and I'll have to know if there were any payments made, because I have to disclose all those things. Give me 1 second, because there are people in the waiting room, so I'm going to let them all in. Here we go. Okay, so letters of protection. So this is the new statute, Florida Statute 768.0427, specifically regarding the disclosure of letters of protection. This particular part of the statute talks about the definition of a letter of protection. And what it says is that the term includes any arrangement, regardless of whether it's referred to as an LOP. So all of this depends on the judge. It depends on how a judge interprets this, because we don't have any guidance from any courts that have any authority to tell us how to interpret this. So, for instance, recently in a case that I'm currently litigating, I was in front of a judge, and unbeknownst to me, the client had signed an LOP. It literally says letter of protection at the top of it. And I did not get a copy of that document. The only reason I knew that that document existed was because the defense sent a subpoena to the medical provider, and then the medical provider produced that in response to the subpoena, and I requested copies. So I knew that there was an LOP by the time this hearing came, but significantly, the LOP was only signed by the client. So the defense attorney was moving to exclude this treatment provider's bills and records because we did not disclose the letter of protection. And this particular one said letter of protection. Fortunately, the judge said that it wasn't my fault. I didn't sign it. I didn't know about it. So I was not in trouble or sanctioned. The bill wasn't excluded because I didn't produce the letter of protection. But now we have to disclose letters of protection. So there are a whole bunch, as you can see, a whole bunch more requirements if there is, in fact, a letter of protection. And I'll just go through quickly what the statute says. We have to disclose not only the LOP or what's purported to be an LOP, but we also have to disclose an itemized billing statement, including CPT or HCPCS codes. We have to disclose if the medical provider sold the account. And if you sold the account, there are other required disclosures. We have to disclose whether the patient/client had health insurance and who the health insurance carrier is. And just so everyone knows, clients don't always tell us if they have health insurance. We ask, but sometimes that information gets lost in the case. And so if you have it in your records and we haven't disclosed it, then there's a problem. We also have to identify the person who made a referral if there was a person who made a referral under the LOP. So for instance, if it's an attorney, we have to disclose the financial relationship between a provider and our law firm. So, and that entails the number of referrals, the frequency of referrals, the financial benefit gained or obtained by the attorney. Fortunately, we don't have referral relationships with doctors. We have preferred providers, and many of you are in this Zoom discussion today, which we really appreciate. But so I can fortunately say to the court that we don't have financial relationships, but there may be some attorney offices who do, and so they will have to disclose that. Just so everyone's aware, Central Florida is very different from South Florida, obviously in more ways than one, but for purposes of this new statute, it's very different. In Central Florida, what the judges are saying is that an attorney has to introduce an LOP before we can present evidence of the bill. So in other words, by the time we get to trial, we have to present the LOP and then we can talk about the bill. In Orange County recently, Judge Sandor made this ruling that LOPs are a condition precedent to admission of evidence rather than filing a lawsuit. However, in Miami-Dade, Judge Ruiz recently said that he had a case before him. He said that the plaintiff had failed to produce an LOP before a discovery cutoff. So the plaintiff did end up disclosing the LOP, but didn't do it before the discovery closed. And the judge said that even though the attorney disclosed it, that bill was inadmissible. So the attorney could not talk about the medical expenses, could not tell the jury about them, and in the end, didn't get the bill paid, even though he got a verdict in favor of his client. He was not able to talk about that particular bill. In that same case, there were several providers where the defense attorney, actually, the indication is that there were no LOPs, that they just were operating under this relationship that a lot of us do, a lot of my clients do with our preferred providers, where they hold the bill but don't sign an LOP. And the judge in Miami said that those providers' bills were not admissible. So those bills didn't get paid either by the jury, so because they couldn't even talk about them. So what happens if you hold the bill, but you don't require the client to sign an LOP or the patient to sign an LOP? In that case, we may need an affidavit from your records custodian or corporate representative about the lack of an LOP. But so far, I haven't been in front of any judges who are requiring that in Central Florida. That kind of goes to the next point that I want to make, that the testimony of either your records custodian or your billing representative or your corporate representative is going to be crucial now. We're going to have to get testimony from them about the amounts that are due. The defense is probably going to ask whoever shows up and represents the doctor's office why you held a bill if you did not have a guarantee of payment. And I foresee that question coming up all the time. And when I was preparing for this webinar, I thought, what are some responses that I could give you, because this is like a new thing that has just come up. And I thought of some possible responses. So think about saying these. If the question is, why did you hold the bill if you did not have a guarantee of payment? You could say, well, we just continued to bill PIP. So just like us not collecting the copay, the 80% after PIP paid, we also just held the bill pending PIP. Or the patient could have MedPay, the testimony could be, well, if the patient had MedPay, then we were submitting it to MedPay and we didn't know, so we just kept submitting it. The other thing to know is that there's a remedy for unpaid bills, and it's for the medical provider to go after the patient for the money. So really, in the end, letters of protection are not necessary. There's a contractual relationship when a doctor's office provides medical treatment to the patient, and the patient is responsible for paying those bills. And so whether or not there's some thing that says they'll pay you back doesn't matter, because you have a remedy in the law to be able to get paid. The other thing that we talked about already is that there are referral relationships between attorneys and medical providers. We don't have written referral relationships, but I know that there are some law firms that do. All of that is now admissible. It's all coming into evidence. A defense attorney is absolutely going to get that in and talk about it. It goes to whether the medical provider has an interest in the outcome of the case. So they'll get up and say, well, our expert doesn't care what happens because he got paid no matter what. But your doctor, isn't getting paid unless you win this. So of course he has an interest in the case. And matter of fact, because you have a written relationship or because you have this referral relationship, if the doctor doesn't win this case for you, then you're not going to give him any more cases. So it's a really, really dangerous thing that you just have to be cognizant of and really careful about going forward, especially now because all of these things are required to be disclosed. So I want to show everybody, this is no shade to Sterling Medical Group. This is an old-ish bill, and I can understand why they do this. The client is redacted, so underneath insured, it had the client and his address. But you can see here where it says Christopher Murphy and it has our firm address. And this is problematic for several reasons. Number one, Christopher Murphy is my legal assistant, so he's not the attorney, so that's not correct information. But also, any defense attorney is going to ask, why was attorney information necessary on a bill if there's no financial arrangement? And just so everyone's aware, we do not have a relationship with Sterling Medical Group. We deal with them when our clients choose to go there and may refer clients there if they, for whatever reason, but there is not a relationship. So that is a really, it doesn't look good. It looks bad that they have this attorney listed and I have to explain that somehow. So here's the bottom line about letters of protection kind of going forward. Any evidence that there's an LOP is dangerous. It's dangerous to the case. It's dangerous to you getting paid, because that's really the bottom line is I'm responsible to make sure that all of as a medical provider, your bills are paid. And if I don't know about a letter of protection, or if someone accidentally puts a note in a record that says letter of protection or something like that, then the judge could rule that your bill is not admissible and then it's not getting paid. So I would say be cognizant of what is in your medical records. Make sure that when there is an LOP, you tell us about it and you give us the paperwork, and be careful about how you're formatting your records going forward. If there is not an LOP, to make sure that there's no reason why someone would think there's an LOP or a financial relationship. Okay, the next thing I'm going to talk about is subsection 2 of the statute. It's what is admissible evidence of medical treatment or service expenses. So basically what this says is that satisfied or paid past medical expenses is now limited just to what was actually paid. So for instance, if you charge $100 for a chiropractic adjustment, but you make a deal with the patient for the patient to pay $30 because they're paying in cash, we are only allowed to tell a jury that you were paid $30. We cannot board or tell the jury about the other $70 for your treatment. Even though $100 is a reasonable charge for a chiropractic adjustment, we can't tell the jury about that. So you are only ever going to get paid $30. So other significant changes are all of these. This is what is allowed to be presented as evidence of unpaid charges. So when charges are unpaid, all of these things are what is admissible. So under subsection 1, if the patient / client / plaintiff has health insurance, the defendant can admit evidence of what the health insurance is going to pay you, and if the patient or client plaintiff has any financial responsibility. So for instance, if you charged $100 for an adjustment, but accepted the patient's health insurance, which paid you $25, and required the patient to pay a $5 copay, we are only allowed to tell the jury about $30. Sort of along those same lines, and honestly, probably more upsetting to everyone in the industry, is that if a patient has private health insurance, but you don't submit the bills, which a lot of car accident providers don't do, they don't take insurance, they don't submit it to health insurance, the defendant can actually admit evidence of what health insurance would have paid you if they can get it. Along those same lines, so number 3 under this part of the statute is that a defendant can admit evidence of what 120% of the Medicare reimbursement rate was at the time of the medical service for each CPT code to show that your bills are too high. And I'm sure every single person who's attending this knows that Medicare reimbursement rates are ridiculously low, and they're not a true indication of what doctors and what doctors' offices should be paid. But general jurors don't necessarily know that, and that's a difficult fact to convince them about sometimes. You also, if you sell the bill, then a defendant can show how much you sold the bill for to show rather than the full amount of the bill. So in the past with billing ledgers, what we used to do in trial is I would have the big stack of bills. I would have the client on the stand. I would say, are these your bills? They would say yes. And I would admit them, ask the judge to admit them into evidence, and the judge would. Whether the ledgers were itemized didn't matter. There never needed to be a deposition of the records custodian, generally in my practice, because I would agree on the bills and records that are coming in with the defense attorney. Also, because PIP is a set-off, that's not something that we would tell the jury about, so we could show evidence of what the full charge was. It didn't matter that there was a reduction or a payment by PIP because we would board or tell the jury about all of the medical expenses. Well, now, detailed ledgers are mandatory. They have to show the payments that were made. They have to show each individual service. So they have to show the CPT or HCPCS codes. And there is a lot more scrutiny about each line item. So what these defense attorneys are doing is they're hiring these billing and coding experts to go through your bills and to say that, number one, your prices are inflated for what, using whatever sort of evidence they have. And number two, that the particular charges maybe are not necessarily related. So for instance, sometimes in litigation, we make the decision to drop part of a claim. So if I have a client who was in a car accident and they say they got carpal tunnel and spine injuries, sometimes it is in the best interest of the case to drop the carpal tunnel part argument, that we don't claim the carpal tunnel as part of the car accident for whatever reason. What these experts are doing is going through every single bill and figuring out which CPT codes were related to carpal tunnel and basically taking those out, saying that you shouldn't have done that because it wasn't related to the case, so you shouldn't be paid for it. I guess the implication is that you should be paid from some other mysterious source. So that's an issue that we're having. So the testimony about how you established your prices is absolutely crucial going forward. The statute still says, you can see it right here, number 5, that any evidence of reasonable amounts billed to the claimant for medically necessary treatment or services provided is admissible to show what the bills were. So this is the same as it always has been. It's codified in this statute now, so they made it in the law rather than just in case law. But there are issues with that because all of those other things are coming in. So we can retain experts. That's something we can do. I'm sure you all know that it's incredibly expensive to do that. We sometimes don't even know, however, that the defense is challenging your prices until it's too late for us to retain someone. And so if that happens, we're going to have your records custodian or your corporate representative or whoever, they'll have to testify about the prices. They'll have to testify about how they're reasonable. We will absolutely need them to say, yes, when we formed this practice, we asked 100,000 doctors in Central Florida how much to charge for a knee replacement surgery, and our price is right in the middle of all those prices. That is something that we're going to have to elicit, and we're going to have to get that testimony before we even get to a trial now, unfortunately. So with future medical expenses, it is not enough anymore for the provider to say in the notes that a particular procedure or treatment is recommended. Now we have to have evidence, and it has to be in the records that we're producing from the very beginning that say what the specific procedure is and what the cost of that procedure will be. So for instance, if your office is recommending a surgery, it has to include the price for the physician actually doing the surgery center, and the cost for the anesthesiologist. If we don't have all three of those things, the only thing we can talk about at trial is what we do have. So most likely the actual surgeon doing the procedure. At the very least, what we need going forward from you all providers is for you to tell us at the very least who to contact if there's someone else we have to contact to get those estimates. And that's one of those things that why I kept harping on that we need it fast, because we have to disclose those things within 60 days of filing the lawsuit. So it takes time. You know, we have lots of cases, of course. You have lots of patients. And so getting together with someone and asking them for that is time consuming. So we need those things quickly. So like past medical expenses, evidence of private health insurance prices or 120% of Medicare can come in to show your future, that your future projected cost for whatever procedure you're recommending is unreasonable. I will say this, a lot of the things that this statute allows or in South Florida requires come into evidence are impossible. I recently dealt with this in another case. My client had Cigna. She did not use Cigna to treat. And the defense attorney argued that we were required to present evidence of what price the doctors would have charged had they submitted the bills to Cigna. Well, if you call Cigna, and I know this because my legal assistant called, Cigna doesn't have prices. They can kind of give you a ballpark figure for how much they would charge a provider or how much they would reimburse a provider, but they don't have lists of these things. So us getting them is impossible, but along those same lines, it's not possible for the defense either. So I know this sounds alarmist, but it maybe is just not a thing that's possible. But either way, it's worth remembering that that's something that could happen. In any case that anybody litigates, that I litigate, spending money and costs is one of the things that I really worry about. All of the costs that are incurred come out of a client's settlement. And the reason I mention this is because depositions and experts and mediation, all of those things are really expensive. And I have to make sure there's going to be a return on investment. So if I have to do more depositions in a case, which I'm going to have to do now, I will spend more money, and that means the client gets less money. What used to happen is we would just wait until the last minute to take a deposition, or maybe just have a quick call with the provider to say, hey, what's your testimony going to be? And that would be sufficient. But now defense attorneys are making these arguments that if we haven't presented evidence of something during discovery, we're not allowed to ask about it at trial. So for instance, if the doctor told the patient they needed a knee replacement and didn't put a full surgical recommendation in the records with the cost of the physician, the surgery center, the anesthesiologist, some of the more aggressive defense attorneys are filing motions, and for the attorneys in the room, they're filing MSJs on this issue, that since we have not produced sufficient evidence of the need for future treatment, we can't bring it up in trial. We can't talk about it. We can't have the doctor testify about it, which means the patient is not getting money to pay for that future treatment from the jury. Another issue I recently dealt with in Seminole County is that I listed the doctor on a document I titled Plaintiff's Expert Witness Disclosure. And I put the doctor's area of practice and said that he would testify, among other things, to causation and the plaintiff's prognosis. I based the causation part of that on a note in the medical records that said mechanism of injury. And the defense attorney filed a motion for summary judgment saying that because the doctor did not explicitly say this accident caused this injury, that I was not allowed to have the doctor testify or talk about causation. Unfortunately, I remembered that one note in one part of the medical records was correctly said mechanism of injury, motor vehicle accident. And so the judge agreed that that was enough to give the defense notice that the doctor would talk about causation. So it's no longer, it can't be the practice anymore. For instance, I know Dr. Bierman. I know that he's going to say that a car accident caused the disc herniation because I've worked with him for a decade. And I know that generally, unless something strange has happened, that he's probably going to say that. And I could pretty much count on that. Well, now, if it doesn't say that in the medical records, either I have to take Dr. Bierman's deposition really early and have him say that, or we're not going to be able to talk about causation. And all this equals is spending more money. I'm sure you all know how impossible it is to get medical providers. Some of you are medical providers. It's very difficult because you have patients to see and you're practicing medicine, but it's hard to get you in a room to do a discovery deposition. So a call used to be sufficient, and it used to be a quick way to say, hey, by the way, are you going to be able to talk about causation? We can't do that anymore because it doesn't matter what you tell me on the phone. It matters what's in the records. So again, just like the billing statements, the records matter. We need them to be explicit and say exactly what you would talk about at trial. So I realize that we're going to be asking a whole lot more from each of you. Please remember, it's not just to help our case, but at the end of the day, it's to make sure that we are able to get your bills paid. You provide really important and significant medical treatment to our clients, which we appreciate, and have to make sure, number one, make sure that you're reimbursed for that medical treatment. So we need your help now more than ever to make sure that we're able to do that. I'm sure that eventually the Supreme Court is going to hear about the statute and determine whether it's unconstitutional, which some judges are saying, or something like that. But until then, we are going to have to jump through these hoops together, and we appreciate all of your hard work. So I'm going to go to questions and see. I don't think anybody put one in the chat, but if anybody has a question, you're welcome to unmute and ask anything that you want to ask. I think you're able to unmute, or you could raise your hand and I will unmute you. All right, I don't see any questions. I am available. I'm sure, hopefully you all have my email address, my phone number. You have our marketing. Can we get a copy of this webinar? I will make, not me, have a team that does all these things. And thank you, Alec and Bridget, for putting this together. We will make sure that everybody who was in the webinar today gets a copy of it so that you can share it or do whatever you need to do with it. So Vinny and Grando asked, when you set the prices, you used 200% of the Medicare rates. And now, is it changed to 120%? So no. In Central Florida, the answer is no. So now, what is admissible to show the reasonableness of your bills is potentially 120% of Medicare. So what will happen is we will go into a courtroom. Vinny, you will say, we set the prices because we set them at 200% of Medicare, because it's okay, Vinny, because everybody sets them at 200% of Medicare. Every chiropractor in Longwood, Florida, every chiropractor in Central Florida set their prices using 200% of Medicare. And so that's reasonable in the community. What the defense is going to do if the person does not have health insurance or has Medicare, the defense is going to say, hey, this is what 120% of Medicare is. And so that's reasonable, which is why it's really, really important for you or your provider, whoever is testifying about your prices, to explicitly say that this is reasonable. These are reasonable prices. This is how we got here. And this is why everybody in this community set the prices this way. So no, it hasn't changed to 120%. PIP also hasn't changed, just in case anybody was confused or concerned. PIP still pays exactly like it did before. This is all about, in Central Florida, what defense attorneys are able to introduce into evidence to show what is reasonable. No problem. All right. I don't think there are any more questions, but please reach out if you have any. Oh, South Florida. So that's the thing. So I am a member of the Florida Justice Association. So we have a database that I can go on and I can pull orders from all of the trial courts where there have been orders submitted. So I know that this judge in South Florida said this made this ruling because I have a copy of the order. So in particular in South Florida, what the judges are saying is that in order for us to even introduce to show your medical your bill, we have to, number one, disclose that there's an LOP. We have to give, and there are a lot of variables, but let's just pretend like it's a person with private health insurance, that we have to give prices that you would be charged or that you would be reimbursed by private health insurance, and that we have to do all that in order to be able to talk about your bill. So if we don't do all those things before the trial happens, and really it's not, in South Florida, it's not about when the trial happens. A lot of the time it's been during the process of discovery. So if you don't do this, if you don't disclose these things way before trial, then you don't get to talk about the bill from that particular provider. In that really terrible Judge Ruiz order where he said there was no LOP, but there was no evidence that there wasn't an LOP. The judge said, you can't talk about the bills because you didn't disclose an LOP that doesn't exist, potentially. So that's terrible. And some other judges in South Florida are saying that in order for us to actually file a lawsuit, we have to disclose whether there's an LOP. So it's a condition precedent. So before we even file, we have to give whoever, and this is again one of those things that the legislature, I guess, thought was a good idea, but in practice, it's impossible. I guess we would send it to the adjuster, but we have to tell the insurance company that there's a letter of protection, or that there, I guess, purports to be one, may be one. So that's South Florida, which is why I think I'm sure every attorney in here can say this is going to go to the Supreme Court because we have absolutely no guidance. We don't have any idea how to interpret this, any of the statute, pretty much. So it'll go up on appeal. It's on appeal already. It'll go further on appeal to the Supreme Court, and we'll get some guidance eventually. But for now, this is the state of things, the state of affairs. So thanks for the question, Ginger. So starting in March of 2023, the statute of limitations for negligence cases in all of Florida changed to 2 years. So what's happening now, because I'm sure you know, that a lot of the time, 2 years in, people who have injuries that result from car accidents maybe they're not even halfway through treatment. We don't even know if they're going to need to have surgery by the time we have to file a lawsuit now. So what'll happen is we will be filing suit on people who are still treating and getting significant treatment. And we have to supplement all of the discovery every time the person goes to the doctor again. We have to get the records. We have to send it to the defense. It's really a really difficult process. So it is in effect now. It's for all cases that are filed going forward from now. And it's any case that is from 2023, March 23rd of 2023 going forward. And yes, all of Florida. So Ginger said, thank you for all your hard work and making the information available. You were so welcome. I'm here for any questions. We are all in this together. Vinny and Grando said, great webinar. Thanks for putting this on. Bridget, our marketing director, just told me to read the stuff out loud. That's why I'm doing that. So thank you all so much for attending. I appreciate you all, and I'm here for any questions that you have. And I hope you have a great day.